digital era has ushered in unprecedented levels of data collection and accessibility. This has raised growing concerns about personal privacy and the right to control one's online presence. The right to be forgotten, enshrined in Article 17 of the General Data Protection Regulation, GDPR, allows individuals to request the removal of personal data from online search results and any files. However, this right is not absolute and often conflicts with other fundamental principles, such as the public's right to access information from administrations and records. This conflict is particularly evident in the context of commercial registers, which serve as vital repositories of information about companies and their representatives. These registers play a crucial role in ensuring transparency and fostering trust in the market. The recent ruling of the Court of Justice of the European Union, CJEU, in Case C-200/2023 has further clarified the limitations of the right to be forgotten when it comes to data contained in commercial registers. It is one of those rulings that says more through what it does not explicitly state, leaving much to be inferred from what it does. This ruling has significant implications for both legal professionals and businesses. The CJEU's decision emphasizes the need to strike a delicate balance between protecting individual privacy and safeguarding the public interest in accessing information. Commercial registers, by their very nature, are designed to provide transparency and facilitate informed decision-making. The information they contain is often essential for conducting due diligence, assessing creditworthiness, and preventing fraud. Therefore, the right to be forgotten cannot be applied indiscriminately to data in commercial registers. The Court of Justice of the European Union ruling provides valuable guidance on navigating this complex intersection between privacy and transparency. It underscores the importance of considering the specific context and purpose of the data in question when determining whether the right to be forgotten applies. This nuanced approach ensures that the right to privacy is protected without unduly compromising the public's right to access information. The CJEU's decision in Case C-200/2023 provides a framework for assessing the legitimacy of data deletion requests in the context of commercial registers. The court emphasized that the right to be forgotten is not absolute and must be balanced against the public interest in accessing information. This means that not all data deletion requests will be granted, especially when the information in question serves a legitimate public purpose. The ruling highlights the importance of considering the nature and purpose of the data held in commercial registers. Information deemed essential for transparency and legal certainty, such as the identity of company representatives, legal transactions, and professional addresses, is unlikely to raise doubts. This is because such information is recognized as crucial for ensuring accountability and preventing fraud. However, the CJEU also acknowledged that other types of data may be eligible for deletion if their publication is no longer necessary or proportionate to the public interest, such as marital status or ID card numbers. Similarly, outdated or irrelevant information that no longer serves a legitimate purpose may be considered for deletion. This nuanced approach allows for a case-by-case evaluation of data deletion requests, taking into account specific circumstances and balancing privacy with transparency. The higher court's ruling provides much-needed clarity on the scope and limitations of the right to be forgotten in the context of commercial registers and the refusals by registrars who cite the GDPR as an excuse. Thus, it establishes a framework for balancing conflicting interests and ensures that the right to privacy is protected without unduly restricting public access to essential information. This decision marks a significant step toward a more balanced and nuanced approach to data protection in the digital era. The CJEU's ruling in Case C-200/2023 also has important practical implications for legal professionals advising clients on data protection matters. Registrars, as public officials, must be equipped to proceed, also free of charge, with the deletion of data related to their commercial registers, taking into account the principles outlined in the ruling. Additionally, lawyers must guide their clients on GDPR compliance and the CJEU's interpretation regarding registers, ensuring that excess data is deleted ex officio. Legal professionals should help clients understand what information can be legitimately requested for deletion and which data will likely remain publicly accessible. This requires careful analysis of each case's specific circumstances and the nature of the data in question. The ruling also impacts the responsibilities of commercial registrars. Registrars must now implement clear and transparent procedures for handling data deletion requests in accordance with the ruling. This includes acting ex officio and carefully evaluating each request, applying principles of proportionality and necessity when deciding on data deletion. The CJEU's ruling in Case C-200/2023 establishes a framework for navigating the complex interplay between the right to be forgotten and the public interest in transparency. This ruling clarifies the responsibilities of commercial registrars in managing data deletion requests and provides individuals with remedies if their requests are denied. This framework is essential to ensure that both privacy and transparency are adequately protected. Commercial registrars play a crucial role in implementing the CJEU's ruling. They must develop clear and transparent procedures for handling data deletion requests, ensuring decisions are made in accordance with principles of proportionality and necessity. Excuses based on the GDPR are no longer valid. All the information they hold, following this ruling, is public and can be requested through public access to documentation. This includes providing registered individuals or applicants with clear information about their rights and the process for submitting requests. Individuals whose data deletion requests are denied have several remedies. They can report or appeal the decision to the relevant data protection authority and also seek judicial review of the registrar's decision. These mechanisms ensure that individuals have the opportunity to challenge decisions they consider unfair or unlawful. The CJEU ruling provides a roadmap for the future of data protection in the context of commercial registers. It strikes a balance between privacy and transparency and offers a framework for resolving disputes. This is a significant step toward establishing a more balanced and nuanced approach to data protection in the digital era.